Back with us, Chuck Rosenberg, Andrew Weissman, Lisa Rubin, and Kenji Yoshino. So, Chuck, and just we've been fascinated by just the way that this Supreme Court asks questions, the way the justices ask questions, and sometimes even kind of interrupt each other. But this is pretty much how the Supreme Court is run.
Well, the dynamics are interesting. The justices ask whatever questions they want in whatever order they want. They can revisit questions. They can persist in their questioning. And of course, they try to be courteous to one another and to the litigants. But the justices ask whatever is on their mind. Presumably, Jose, they've read the briefs. Presumably, they've discussed the case with their clerks. But you're quite right. The dynamics are fascinating.
Did it surprise you that the issue of insurrection, how it was defined or not defined, was not a big part of that conversation?
It wasn't. It wasn't until Justice Jackson brought it up that we even heard discussion about it. I thought Mr. Trump's lawyer's response to that was quite interesting. He said a couple of things. He said it was a riot. And he said it was shameful. It was certainly at least those two things. He maintained that it wasn't an insurrection, at least legally. But the focus today didn't seem to be on whether or not there was an insurrection, whether or not Mr. Trump had engaged in one. It really took the form of other arguments. Do we need Congress to enact legislation to give effect to the 14th Amendment and Section 3 and its disqualifying provision? Is the president an officer of the United States? That was the focus, at least, of the Trump argument today. And you're quite right about the insurrection discussion, Jose. Really was, well, first, didn't come up for quite a while, and second, was a bit of a sideshow.
Let me bring in Lisa Rubin, MSNBC legal analyst, former litigator. And Lisa, I know you listened very closely, as we all did. I'm wondering if you have a different takeaway than what we've already heard. And if not, what do you think is the timeline here on how quickly we might receive a decision? Because we know that ballots are going out. Super Tuesday is less than a month away, when a number of states, including Colorado, will be casting votes.
Well, Anna, let's start from where I think some of our other friends have been. I fully agree with the number of votes I think you'll see to overturn the Colorado Supreme Court. And the moment that I said to myself, I've seen enough, was when Elena Kagan point blank asked Jason Murray, her former clerk, why is it that you think that one state should be able to decide the presidential election for all states? That was the moment in which I knew that this argument was going exactly where we thought it was. Everyone is just searching for something to hang their hat on, interpretively or otherwise, to get to that place. And one thing I also found interesting, looking ahead in terms of what's coming down the pike, this is a court that heard argument today about the 14th Amendment and Trump's qualification for office, while it knows that on Monday or before, former President Trump will ask them to stay a D.C. Circuit's ruling so that he can appeal their decision with respect to his immunity from prosecution. And that seemed to be very much on the justices' minds today. In particular, Justice Kavanaugh searching to understand, are there other ways in which, barring impeachment, a former president can be made ineligible to hold office? And he invoked a particular federal statute that I think Chuck and our other federal prosecutor friends are very familiar with, 18 U.S.C. 2383. And if you're convicted of that statute, which was not charged here by the Department of Justice against Trump, but if you are convicted, you are disqualified from holding office. Jonathan Mitchell, the lawyer for Trump, made very clear he agreed with Justice Kavanaugh on his interpretation, but said, of course, we're not conceding that because we believe that former President Trump is presidentially immune. And Justice Kavanaugh didn't want to engage in that issue now, but to me, that signaled one of the things that Justice Kavanaugh is thinking about is that in overturning this Colorado court, one of the things he can say is, but of course there are other remedies here. And one of those remedies is that the Department of Justice can prosecute a former president for insurrection and thereby disqualify them from holding office in the same way that Congress can by using the 14th Amendment.
And Lisa, in a way, they couldn't have planned it this way, but in a way, the way history has evolved in the last couple of weeks, the Supreme Court may be inoculating itself from coming down heavily on one side or the other by siding with Donald Trump against Colorado in this case is if, as we seem to be all agreeing, they probably will, and then in some fashion either not accepting cert on the immunity issue or disposing of it in a way that still leaves Donald Trump vulnerable to whatever the Justice Department, just, you know, the course of justice, rather, in these cases, in these trials, if they proceed, and if they are not further delayed beyond the election, will have their effect with judges and juries.
I think that's absolutely right, Andrea. I think that we could see the court dispose of both of these cases in fairly short order. They could even do so on the same day because, as you noted, this case is now fully submitted. We seem to have at least 8 votes, maybe 9, to overturn the decision of the Colorado court. On what grounds, I think, remains to be seen. But they could very easily refuse to grant cert on the immunity case and allow Judge Chutkan to move forward with that case pre-election, and at the same time say it's not for a single state to determine by invoking the 14th Amendment the qualifications of a former president to hold office, either because it's premature, as Jonathan Mitchell argued at one point, for Colorado to essentially interfere with the constitutional timeline, or because, as Justice Gorsuch was flirting with, there is a distinction that removes the presidency both from the definition of the word office and officer of the United States. There are a lot of interpretive off-ramps for them, and we'll see which or many of which they take here. But I do agree with you that this has been set up for them as to sort of split the baby with the bathwater in a 1-2 punch.
You know, Chuck, I want to come back to something you mentioned at the beginning of our transmission this morning about judicial supremacy and about Marbury versus Madison. And I'm just thinking the weight of history on this day and how much, for example, the Bush v. Gore in 2000 that Andrew Mitchell so brilliantly covered, as she does everything, but among so many. But how much does the weight of history have to do, and what does it play in this argument?
Yeah, my sense is that this court, and Chief Justice Roberts in particular, has an eye on that. Marbury versus Madison, an 1803 decision authored by then Chief Justice Marshall, stood for the proposition that it is emphatically the province of the judicial department, that's what he called it, but meaning the courts. It's emphatically the province of the courts to declare what the law is. And that's all we have ever asked our courts to do. But the courts nevertheless have an eye on the importance of history. Let me give you an example. The 1970s were a bitterly divisive period in our nation's history, coming out of the Vietnam War and into Watergate with an investigation of a sitting president, Richard Nixon. When he was subpoenaed to turn over documents to a special prosecutor, the Supreme Court ruled 9-0 that he had to comply with a subpoena. 4 of those justices in the 9-0 decision were appointed by President Nixon. It can't be lost on the court the value of unanimity, and it can't be lost on the court that there's a value in people, justices, regardless of who appointed them, joining in those majority opinions. I think if there is a 9-0 decision out of this court, or 8-1, but a sort of a decisive opinion, whether you love Mr. Trump or loathe Mr. Trump, that's helpful. That people can see that the justices put aside politics and decided the case on the merits. You're still free to disagree. We're all free to disagree. But I think they have their eye on history. There are many examples, Jose, in our past of justices putting aside politics and reaching unanimity. Brown versus Board of Education, 9-0, sent a very important message to the entire nation in 1954, similarly.